we're opening the highway between Maypen and Mandeville. And clearly, I have a great sense of duty, so I'm here, and I have a great sense of longing to be there. So we're here. MP Sybil's can't make it. MP Tamika Davis has tendered her apologies as well. MP Carenza Morrison won't be able to make it. And Senator Longmore has just walked in. And we thank you for coming, ma'am. We just started, and we're even more corporate now. So those are the apologies that I have. We haven't been here for a while. We have been working, however. I know that the team from the ministry has been working. We know that others have made submissions, but the timing will not allow them to be present here today. They're not quite ready in some instances to present. We will wait on them, but we wouldn't hold up the business of the Joint Select Committee by putting off. So the work that the ministry has been doing, and that includes our agencies, main one this morning is the Company Office of Jamaica, and it is that work that we're going to look at after, for instance, we confirm the minutes. Ms. Cohen, you want to move us through that? Okay. All right. The minutes have been circulated. I'm going to ask for a motion to confirm the minutes. Colleagues, on my right, will somebody move? All right. Moved by Senator Longmore. And I see Senator Golding. Seconded. Yeah. Thank you very much. Any matters that may be arising from the minutes? Yes, member.
Just a query. Were the persons from the creative industry, in the aspect, the music industry, were they actually written to and invited to participate?
Ms. Cohen, can you help me there? Nobody followed. I know. Send me a note after today, a WhatsApp or something, and I'll do it. We haven't yet asked the Minister of Culture to do it, but we're going to make sure that's done today, right after I leave here. I made a commitment that I'd talk to the Minister. I went off traveling, didn't do it, so my apology. I will do it after today. Any other matter arise, but we will make sure. Stephanie, you're going to make sure with your left hand that I do it. Thank you. No other matters arising. Then we're going to look at the overview of the Act and recommended legislative amendments by the Ministry. It says the Minister. Steph, you're going to lead, or Ms. Leon? Ms. Leon will lead from the Company's Office, which makes sense. Ms. Leon, you're on. Yes, yes, Senator.
Sorry to revert back to the matters from minutes.
Yes.
Did we get any response regarding my suggestion? Oh, sorry. Thank you. Going back to the minutes, yes.
Yes.
Did we get any response for submissions from representatives of low-wage income earners? And I had indicated especially farmers, perhaps. The farming community.
All right. There seems to be a belief that the unions would cover them, but your request was quite specific. So I'm going to ask Stephanie if you'd be kind enough to talk to me afterwards. We might have to talk to Mr. Fulton and or my colleague minister, Floyd Green, for his input as well, and I promise that I'll follow up on that and make sure it's done.
Thank you, Chair.
Thank you. Welcome, sir. Mr. Williams. Good to see you. No. Yeah, yes, we got the message, and I mentioned it to the committee. Right. If there's no other comments from the minutes, then I'm going to ask Ms. Shelley Leon, who is the interim head of the Company's Office of Jamaica, to lead us through what the ministry has been working on to lay the way. And after this, it might be that some of the matters that others might want to bring up might be answered. That's our hope, but we still will look forward to those submissions and presentations in the future. Ms. Leon.
Good morning again, Chairman Hill, other members of the committee, colleagues. So the Company's Office of Jamaica and the Ministry of Industry, Investment and Commerce, we have been considering submissions regarding the amendments to the Security Interest in Personal Property Act. The last time that we were here, we were asked to provide some background information, so I'm going to briefly give that background information. So in 2013, the Security Interest in Personal Property Act was passed, and it was implemented on January 2nd, 2014. So despite the existence of a wide variety of financial institutions, there was found to be a gap in access to credit in regard to not so established businesses and SMEs. So for persons owning real property and well-established businesses, the access to credit was found to be easier. Accordingly, there was found to be insufficient funding to other key sectors or persons, which consequentially stifled the potential growth of the country. The SIPA aims, therefore, to allow the recognition of non-traditional or movable assets forming collaterals for loans. A modern secure transaction regime promotes and revitalizes commerce by facilitating the pledge of personal or movable property as security for a loan by a borrower. It seeks also to remove any ambiguity relating to the property pledged, to whom such property was pledged, and allows the secured creditor the right to seize and repossess such property speedily upon default of payment. Without the protection of this legislative framework, industry lenders would continue to be unwilling to lend against this type of assets. So, what was the objective in regard to establishing an online NSIP registry? So, among the objectives are to provide a practical, effective, and sustainable system for publicizing rights, so that other potential lenders can determine whether an asset has already been pledged to somebody else. To allow for the establishment of priority rights to collateral in the event of dispute among creditors and other third parties. And to provide speedy internet access to information regarding the filing of security interests. So what is the user profile that we've seen regarding the security interest in personal property registry? So since commencement in 2014, at the inception, 473,002 notices were uploaded to the registry. a query of the register showed a steady increase in usage between the years 2015 to 2019, with a total of 196,201 notices registered in the said period. For the periods 2017 to 2019, the highest usage of the registry was recorded, with in excess of 40,000 notices being registered annually. However, during the pandemic years, so that is beginning 2020, we saw a 19% decline in the number of notices. And in the years 2021 to 2022, although the number of notices filed increased, it was still below the pre-pandemic levels. However, we're very happy to report that in the current year, as at August, the registry has recorded 26,414 registration notices. By way of analysis of these monthly trends, a projected 3% increase registration over the last financial year is forecasted. Now, it's interesting to note the collateral types that we have seen being used. So the most frequently used collateral types, these are furniture, security, fixtures, and motor vehicles. Note, however, that in total...
Furniture, securities.
Yes.
Securities. Yes. Okay.
Securities, my apologies. However, a total of 19 collateral types have been used. And the 5 key sectors utilizing the services of the registry: consumers, commercial sector, mining, agriculture, and the government of Jamaica. Now, interestingly, and this is major, a query of the register indicates that 21,144 debtors secured loans totaling values in excess of 11,451 billion Jamaican dollars. And we can see that this amount, it has been increasing over the years, because we observe that even while the number of security interests declined during the pandemic, the values of loans increased for those who did take loans. Of the over 11 trillion in credit secured under the regime, 226,358 SMEs and non-SMEs secured in excess of 10 trillion in financing.
I just want to make sure we're talking about $11 trillion. That's a big number, really. It's impressive. Go ahead.
And it's also interesting to note that according to the statistics provided on the notices, more female businesses secured loans when compared to male-owned businesses. The statistics indicate...
I personally want you to repeat that again so I can hear it clearly.
The statistics indicate that more female-owned businesses secured loans when compared to male-owned business entities. So, whereas 90,406 entities were female-owned, those that sought financing, 86,760 were male-owned.
Chair, do we have a breakdown? Do we have a breakdown of the areas of focus of the businesses related to that gender?
No, so that
divide?
statistic rather is not yet collected on the register, but we do take recommendation from stakeholders in regard to amending what data is collected. So this is something that we can make a note of
Yes.
and see. And of course, this is voluntary in terms of when the persons fill
Right.
in the notices, they can choose whether or not, but we can certainly put that.
Please, and I would also be curious as to especially the agricultural breakdown, the agricultural sector breakdown as per gender, and also the age group, as in the ages of these women who are seeking this, you know, the significant information could be had from that. I think of single mother households, etc.
You want all the data for the gender,
The gender and particularly in agriculture. Thank you.
All right, we will make this recommendation. All right, thank you. All right, so as against that background that we just gave, we have, in order to make the regime more effective.
Ms. Leon, maybe before we move, it would be interesting as well to get the data of the percentage of women who apply, who get it, the percentage of men who apply, who get the loan, because it's important to know what the rejection rate is. More importantly, let's put it positively, what the uptake rate is of those who apply. Okay?
Chairman, perhaps the factors that lead to acceptance or rejection, in the sense that we could tailor solutions to such.
I think we might be able, you can look at that, although now that's getting into the interaction between the lender and the borrower. That's probably a little bit too fine, but we'll ask you to look at it, and if an appropriate question can be phrased that might capture that, then we can.
Chairman.
Member.
Recognizing that what the company office does is to operate a registry. I don't know that that rejection rate is properly a question for the registry. The registry just simply registers the security interests.
You know, it's a fine point, but given that we can ask the number, the information, and it's voluntary, people can choose to give it. So given that it will help to advise policy, if we put the question on and they don't answer it, we leave it as it is and we learn from it and take it off.
I believe the question
Is out of order?
no, I believe the question is a question that I think for public policy purposes we need to get, but I think we're looking at the wrong source. I think we need to go to the financial institutions and the other institutions that are making the loans.
No, they're having run one. There are other people who collect that data, but we also know in government, and certainly since I've been there, that the COJ has to be a place where we become a repository for data. And I don't have any objection if they would ask, and most people will give it to you because it's voluntary. And if we get the number, then it will collaborate other sources that might be collected or might not be collected right now. So I don't mind that the company office would ask and get that data. Continue, Ms. Leo.
So in light of this background, some recommendations have been made to improve the legal framework so that this regime can be more effective. So the summary of the recommendations, I am just going to give a synopsis in terms of some of the provisions that we have suggested.
Can I, before you get to your summary, I wonder, I don't know why I get feedback. I noted in your, on page 11, you concluded that you didn't think the regime had achieved its objectives. And I wondered why you came to the conclusion. It sounds to me like you're partially gotten there, that there are some obstacles that you need to address. But I was a little surprised given what I would consider the large number of loans that have been disbursed, that you felt you had not accomplished the objective, that the act hadn't accomplished the objective.
All right, so What it is,
I'm looking at page 11. Can you just read the, it's in the summary, member?
Yeah, well, it's the first paragraph, so I can read. The question posed for consideration earlier in this report is whether the implementation of the secure transaction regime has achieved the objective of increasing access to credit to key sectors and individuals. It is recognized that a conclusion cannot justifiably be reached without an analysis of the previous landscape. However, in light of the findings above, it is possible to conclude that the regime has not achieved its objective.
All right, so at the outset, it would have been indicated that the background that existed is that there needed to be a diversification of lending facility available to, for example, SMEs. So whereas we have seen that there has been a significant uptake in terms of financing, the different aspects of the report indicates, for example, that intellectual property and other type of personal property, these are still...
Can I interject here?
Yes, yes.
Then what is written is not well written. You have to rewrite this so that, because it makes it sound, I'm agreeing with member that it sounds like it's a blanket, it didn't work at all. And that's not what you're saying now.
No.
So we need to rewrite this to make it more specific and accurate. And, you know, I know you're a lawyer, so you know how specific it has to be, because if you can have two interpretations for what is written, then it's not clear.
Thank you. I'm guided.
I mean, it's a mixed bag, meaning you have accomplished some things, but there are some obstacles,
yes,
which is what we are looking at now to see
right,
how we can overcome that. You said
right,
intellectual property remains, and I've looked at that, but again, that's not an issue specific to the Act. There
right,
are other problems about how you value intellectual property, right, that has contributed to the low uptake there. But in some areas, you have accomplished
in many
something.
areas.
In many areas.
Right. So it is not well written. So we will redraft to reflect what was truly intended.
In fact, I would suggest that the Act has worked well.
It has.
And really, it just points up the areas in which we need to make some further adjustments so it can work even better.
11 billion certainly caught my attention. If you're getting trillion, when you're doing that kind of number, something has worked.
Right.
Okay. So we need to rewrite.
We will, because it has worked well, and several institutions have developed other lending products, which, especially the agricultural sector, they have accessed. So we will redraft.
I'm agreeing with you. I'm particularly concerned about intellectual property and the uptake there. That's why I keep asking if we've written to the music industry and the creative industries to see how best they can participate, or even whether they really have knowledge about the opportunity or the possibilities.
Thank you.
Thank you. Go ahead.
All right. So in terms of the recommendations for amendment, we want to amend Section 2 to provide more comprehensive and applicable definitions. So, for example, we want to define who an account debtor is, and instead of merely referring to serial number, we now want to define serial numbered property, as this would have wider applicability, because in the Act right now, serial number merely applies to motor vehicles, but there are several other assets identified by serial number. And we want security interest to expressly include accounts receivables, leases, and consignments. In Section 5, we want to address provisions which were misplaced. So we want to remove certain subsections and place them more appropriately in a new section. Section 8, similarly, that section deals with disposal of secured property. And so sections which were not applying to that, we want to remove to a more appropriate new section. For section 11, we want to provide an exemption for continuation of security interest where property is transferred. So section 11 addresses when a security interest continues after the transfer of secured property. The exceptions to these provisions are provided for in Part 4 of the Act. Therefore, we want to make the reference to Part 4 in Section 11. For Section 18, the priority for consumer goods exceeding $10,000 against security interest not perfected by filing. This section currently provides for the treatment of consumer goods not exceeding $10,000. A new provision is being inserted to provide that where the value of the consumer goods exceeds $10,000, the buyer or lessee takes the good free of any security interest not perfected by filing of a registration notice. Yes, Minister.
May I just take it back to, because I've been reflecting on what the point you made about the exception where this is in the previous
Yes.
Suggested amendment, where the security interest is not extinguished, but there's a transfer.
Right.
And you're saying there are some exceptions to the security, because the general rule is if the security interest is not extinguished, then it would follow the asset. What would be the, just give me an idea, I'm just thinking, what would be the exception to that not happening? Because if it's either the security interest has been terminated or extinguished, or it has not. And if the asset is transferred, then I would think that in almost all cases, you'd want that to be indicated that the security interest remains with the asset. So I'm just thinking, what would be the exception, if you can?
All right, so that is correct. And what we also sought to do, so in the commercial space, we desire certainty. So there are some things that are done as practice, but it may not have been explicitly stated in the legislation. So just what you've mentioned, for example, to say, if there's a security interest, unless there is agreement that the security interest not be continued when the asset is passed on, then the security interest would continue. So the Act basically codifies what exists in practice so that there will be no ambiguity and there will be no uncertainty. There may be some cases where another asset is being pledged, and so the asset that was currently being used, that asset will be released. There may be certain circumstances where other, for example, an interest in a new entity, someone, instead of a loan, someone gets shares. And so the loan interest which existed, it becomes an equity interest. So there are certain situations like those, right? Okay. So in regard to consumer, okay, I did indicate, yes, that the provision is being inserted to provide that where the value of consumer goods exceeds $10,000, the buyer or the lessee takes the goods free of any security interest not perfected by filing of a registration notice. So the modus operandi under this legislation is that the general rule is there must be registration for there to be perfection. But for example, consumer goods is one such category where an exception exists. So there was a cap there of $10,000, which persons over time, they have been lobbying that this value, it's too small. And so a change will be made in this area.
What are you recommending?
So we did not yet put a figure. There are some other interest groups that we're aware of. For example, the hire purchase persons who will be coming with a submission and some microcredit interest. So they will be making some submissions and then we will, yes. All right. In regard to section 19, we had previously mentioned extending the definition from serial number to serial numbered property, and so we're ensuring the consistency in the use of that term. For section 32, we're aligning it with what currently obtains under the Insolvency Act. So this section makes it very clear that the interest of an execution creditor will be superior to that of an unperfected security interest, because someone who has an unperfected security interest will normally rank as an unsecured creditor. So we will be putting that principle in this legislation.
Is the term execution creditor, is that defined in this act or in the Insolvency?
In the Insolvency Act. It is defined in the Insolvency Act, and we currently have provision on the NSIP registry for registration of notices regarding same.
Wouldn't it be easier, better than to import that definition in this act as well, to be consistent with the Insolvency Act, so you don't have to be going to another piece of legislation to understand what your the regime.
So I know that, Minister, in some cases, and we're usually guided by the draft person, so in some cases we have indicated in some pieces of legislation that the definition of execution creditors here is the same as applies in the Insolvency Act. So in regard to how we execute these amendments, will be guided by the experts in this area.
And do you think that that would be helpful?
Well, there's a definition currently in this act for execution creditor, so it's a matter of seeing if there are any inconsistencies between the two. But I thought that the point that she was making went more to how it's dealt in terms of the ranking.
All right. In regard to section 33, the proposed amendments will deal with creating an exemption from enforcement provisions of security interest for certain transactions. So the section is being amended by creating an exemption to Part 4, enforcement of security interest, to certain types of transactions, including sales of accounts receivables, so the buyer owns the receivable and the debtor retains no property interest. If the debtor defaults, the buyer retains full value of the receivable. In regard to commercial consignments that do not secure payment or performance of an obligation. So where easier methods of enforcement may be used for certain types of personal property, the general provision which is set out in SIPA will not apply, and we will see later where we've made specific provision for certain types of property and how a creditor can recover other than getting a court order based on the nature of the personal property. For section 35, we are ensuring consistency for use of the term account debtor or providing for the disposition of accounts receivable by a secured creditor. So the section as it appears merely referred to debtor, but it was really specifically dealing with an account debtor, so we will make that indication there. And as regard accounts receivable, a new paragraph will be inserted to authorize the secured creditor with a security interest in accounts receivables to sell one or more of the receivables as an alternative to collecting the debt over time from the account debtor, subject to Section 36, which deals with disposition of security interest, and 37, obligation to give notice of disposition. So it can be easier for a creditor, therefore, to collect some of their debt, subject to compliance with the legislation.
I have a comment here. I like that approach because while you're protecting the rights of the debtor, you are actually monetizing a security by making it tradable without the need to go back to the borrower of the cash. So and then in doing that you will then make sure that there is a lot more transaction and money flowing in the commercial area of the economy. And I mean, we're talking about $11 trillion here. If you, in a year and a half, 2 years, get 3 trillion of that rolling in the market, you actually get commercial activities happening and monetizing of what would otherwise be a dead security, sitting in somebody's vault.
I get the sense of where the chairman is going, and I think that's generally good. My question, though, is twofold. I would imagine that the purchaser, since you're giving a right to the secured creditor to monetize some part of that portfolio,
security interest, yeah.
Portfolio of security interest. But it seems to me that you would have to, that works best in certain types of situations.
That's correct.
And in others, you would need to safeguard the right of the creditor, of the debtor, at a minimum by giving adequate notice.
Yes.
Because those assets would be transferred without the security interests following those assets, because the purchaser will be buying without notice or to make it work, right? So it seems to me we have to define those situations, because in some other situation it could be very oppressive.
Although, I'll let you come in a minute, although I imagine that when that is being done, the way that legislation will be written, it will be making clear that the moment you go, I am going to go and offer, borrow somebody's money and give them a receivable. Immediately, this legislation should be written that whenever I do that, I am agreeing to this and therefore should take protection. I also believe that this can't be done without lawyers doing it. You have to do the transaction. But once why I'm wary of that, member, I'm not against it, but I'm wary of it because I am the I'm the one who borrowed your money. I have the money. You need to get back your money. You can't put anything additional in a contract other than what I've signed already. So I'm protected. I should be protected at that point when I'm borrowing the money. But take a look at it. We certainly want to make sure a market develops for those security, because we want the financial system to be stronger and more varied, given what you had said in fact, speaking about this, Member Robinson, it strengthens your request that what was written in the summary needs to be changed, because this is a big, big plus to to how the economy will work if it works right. So take a look at what Member Hilton has said. Don't make it oppressive, but, you know, I already have the money if I'm the borrower, so make sure it's clean.
So just to note and to assure, so normally under these circumstances, the security contract would make provision, as you've stated, specifying which of the assets can be subject to this procedure. Note as well that this proposal would be subject to Section 37, which deals with obligation to give notice of this.
Oh, there you go. So it's covered.
Yes,
it's covered.
Yes.
Thank you.
All right. In regard to item 10, which deals with Section 37, enforcement of security interests in intellectual property, the section is being amended to include specific subsections where intellectual property is used as security and the debtor defaults. It will provide that creditors may dispose of or grant a license in the property in accordance with the terms and conditions of the license.
Can I just ask you here, it's not specific to your recommendation, but have you examined other jurisdictions where there's greater use of intellectual property as a collateral, and how they got to that point in terms of having, you know, a cadre of professionals who can do the assessment, do the valuation, that kind of thing, because that's our strongest asset that we have, which we are currently not able to monetize.
So we certainly have, and in fact, in collaboration with the Jamaica Intellectual Property Office, we did present some papers on monetizing intellectual property. So we had looked at, Canada, we looked at US and some other jurisdictions. We saw, for example, in the US where they had created new products like Bowie bonds using royalties and so on to secure loans, and, you know, this resulted in huge financial transactions. So we have done some research in those areas. We do have some ideas, and we have presented papers in collaboration with JIPO to see how creatives and so on can leverage their intellectual property rights. So this is an area being worked on very actively. Yes.
What has been the, if I could call it, what are the outcomes or the actions that have flowed from those discussions?
All right, so Miss Lily Claire Bellamy would be better able to give those results, but I can say several agencies, JBDC, JIPO, there are a number of initiatives taking place, even where creatives can formalize for free, get access to financing for free. Our own ministry here, we have a roadshow now wherein we're engaging SMEs, which would include creatives. We're showing them the total suite of what we offer, how they can get help, how their business products can develop. And, you know, so there are a number of initiatives taking place.
I want to say that
Dr. Floyd Morris asked me to remind you of the academics too, who do work and whose work would be very valuable as well.
Yeah, they will come under that.
Yes.
Senator Longmore, you have a comment.
I was just commending that effort in terms of breaking it down for the persons who are not as savvy with this type of lingo and legislation, because it is really very critical that we are able to translate to especially the most vulnerable population who might not be able to interpret the benefits that are there. So just endorsing that and hoping that as we roll out whatever amendments we make to the final act, that we make effort for the public relations arms to break it down, especially to those populations.
I am so pleased that members Robinson and Longmore have gone down that road, so that I can tell you that I think last month we started off with the first roadshow in Manchester. We had hundreds of people there. It's it's the MSME Roadshow is a collaboration actually between the $250,000. We have sponsors such as Sagicor, DBJ, and others are on board. LASCO, for instance, a main sponsor, who have been there with us. And what we've done, we realize, especially from my banking career, that many of these small people don't like to come into big buildings and in banks and things that look like banks. So we take it to them. And what we've done, every single one of the 20 agencies in the ministry, each one is represented there. I'm going to ask Ms. Leon that you get in touch with Lily Claire. I'd like Lily Claire to come here because I talked to her about this. This is vitally important. It's a major growth aspect, especially for a country like Jamaica that has so much cultural activities and academic activities, as Senator Morris has asked to be considered, that we explain to people, for instance, members and the public, at JBDC, Jamaica Business Development Corporation, every single new MSME that comes, there's great encouragement, and Ms. Leon can testify to that, that they get registered as companies, because until they're formalized, they're out there waving in the wind. And so part of our mission is to make sure we get people who are doing business, are not aware of, sometimes even afraid of, all the government stuff that has to go. We take it to them and say, look, this is what we do. So the next roadshow, I think, is in early October, or sometime in October. 5th of October, is it Ocherias or Ocherias? And there's a one in Montego Bay. The last one will be in Kingston before the end of the year, and we'll pick up again next year to make sure ordinary, not the people who have lawyers and accountants, ordinary people who don't have those, get the benefit from the Ministry of Industry, Investment and Commerce. So please make sure you, and Stephanie, you alert Lily Claire that when next we meet, she should come prepared to explain how this works and how we're working and which jurisdictions we've looked at and what goodies we're taking from them rather than recreate the wheel.
I want to support that, Chairman. I look forward to it. I think it's a good suggestion that Jaipo
be here with us.
Be here, and because as you can see from my question from the very big first meeting,
yes,
this area of intellectual property, for the reasons we've been discussing, the fact that there's so much more that can be done in monetizing this asset, that I think we should pay particular attention, and that will really bump up the numbers.
Right, and as we advertise it. Lily Claire, for instance, chairs a major committee of the World Intellectual Property Organization, and they're coming to the Caribbean in the near future, where we're helping to host. So she's the right person to come prepared for this, let her understand the Act, what we're looking for, and specifically, and explain to us and the nation what we're doing.
All right. The next area, Section 48, is consistent with what we've already discussed in regard to use of the term serial numbered property. At item 12, for Section 49, we want to modify the requirement to insert the amount of indebtedness in the registration notice. So currently, the law provides that you would state the amount of indebtedness. We want to modify this to state maximum amount of debt. So as we know, practically from time to time, an entity may receive approval for a loan of up to 300 million. Only 100 million at first may be disbursed. Instead of filing a notice which says 100 million, then mandatorily having to do an amendment notice each time you get a disbursement, there would be a record on the registry for other poor secured creditors to see this asset is charged up to 300 million. All right. The other area is identification of debtor and creditor. And this will become, you'll see why this is very relevant. So what we're doing here is stating in the legislation specifically what data do you need to indicate who is a creditor and who is a debtor. And this will tie into some further changes that I will mention later. So it will indicate, for example, in the case of a secured creditor, you must state the name of the business, you must state their address. In the case of a debtor, name, address, taxpayer registration number.
You're talking about the ultimate creditor debtor, right? Is that the direction in which you're going, where you're wanting to know who is behind certain activities?
That's correct, because a secured creditor must be able to know who to approach. So the registry is a notice registry. What it does, it says this security interest might exist. So you, in doing your due diligence, can know, who do I go to find out what's the actual position, what is happening now? Yes. All right, at item 14, which deals with section 51, this is protection of other secured creditors when a notice is being amended by a secured creditor. So the section currently allows the amendment of a registration notice by one secured creditor, which may prejudice the rights of other secured creditors. The amendment now expressly states, so it no longer leaves it to conjecture, it expressly states that only secured creditors who authorize the amendment of the notice will be bound by it. At item 15, which deals with section 52, this will provide certainty in the law. We are making the change to address the validity of notices with defects or irregularities. So currently, the section does not definitively state that where there's a defect or irregularity in registration particulars, and by that we mean a person's name, their taxpayer registration number, the serial number of property, this will invalidate the notice as against other secured creditors. So this amendment will address this issue. Then at item 16, corresponding with the change at section 52, section 56 will now be amended to remove the registrar's discretion to accept defective or irregular notice. So the section currently provides that the registrar may refuse to register defective or irregular notices. This amendment removes this discretion by providing that the registrar shall not register such notices. And again, this provides certainty in the commercial space so that secured creditors will know what are their rights, basically. At item 17, this deals with the provision for restriction of public access to personal data, such as TRN. So currently what the act says is that the registrar should provide public access to the contents of the registration notice. The registration notice, for example, includes the taxpayer registration number. So the amendment will make it clear that the public, they are not entitled to this data from the registration notice. At item 18, this deals with a provision, making a change to the provision dealing with conflict of laws. So this section doesn't currently address the situation under which the laws of another country may govern a transaction. So the amendment will align our legislation with international best practice by borrowing from the model provisions as set out in the OAS Model Act and the UNCITRAL Model Law. So the provision which was there, it was inadequate because it didn't address such matters as what if the security is not in Jamaica, the location of the parties. So these provisions which are internationally accepted and are best practice, we will incorporate in our legislation to provide more certainty as we promote cross-border trade. So these are the summary of the key provisions that will be promulgated by COJ and MIC jointly, and other stakeholders, as you know, will come forward with other amendments.
Members, Senator Longmore.
Thank you, Chair. My apologies. I just got notification I have to leave prematurely.
Okay.
But I just wanted to thank you for your presentation, and also just to, I've sat in a few joint select, and it is refreshing to hear the effort to collaborate with the other agencies outside of this forum, so that whatever recommendations you're bringing is already predetermined and agreed upon, rather than what tends to happen a lot is that we have to sift through it in this space. So I came across at section 18 where you said the recommendations would be discussed amongst yourselves and then a final decision would be made. So I thank you for that, and I congratulate you on your presentation.
Before I take any more, I want to add my piece to that, because clearly I had my briefing with you guys to go through all this, but the idea that we have in the ministry is that all 20 agencies must collaborate, and since I have the microphone, collaborate with the major intent of doing everything to reduce and change that 61 years that we have of negative trade balance. We have to change that to become a wealthy country, which is what we intend to do. So thanks for the work. It's good work that you've done. Thanks again for the briefing, and the work that you will continue to do as people make their submissions and we have to adjust. I saw Senator Golding Campbell. I'm pleased to recognize Senator Morris, who has joined us. We did get your comments, sir, and we make sure it's infused into the discussion and the work that we're doing, and we're pleased to see you. Senator Golding Campbell.
Thank you, Mr. Chairman. I wish you hadn't said anything and had allowed the committee members to give the accolades.
I can take it back now, and then you repeat it.
So you might
repeat.
be seen as a little biased. But I have to join Senator Longmore in making a comment. I am one of those parliamentarians who read everything that you give me and ask for more to read sometimes. And I don't think that I've come to a joint select committee and had this much preparatory data that makes me not have too many questions to ask at this point in time, because I have a clear understanding of what the Act has done, how the registry has performed, and I am deeply grateful. So I want to acknowledge that to the team. And I also want to ask, it's the only question that I have, and even a little bit more for the purposes of the public as well. I practice in commercial law, so I'm a little familiar with it. But could you just give us a little overview about how the online process and the registry works and how ordinary people access it? And whether or not they can you just tell that for the purposes of the public?
All right, so thank you so much for your kind words. In regard to the registry, so initially the registry was accessible by all members of the public. However, regrettably, we had some persons who were using it to create public mischief. So as a result of that, measures were put in place where usage would really be by persons who had bona fide transactions. So as a result of that, persons are required to create an account, and the identity of the person is verified really. We have access to the TRN, we can verify. We cannot access the database, but we can verify if a TRN is valid. So we do a verification exercise, and then we validate the account and we do so in a timely basis. So once you've created an account, then you can, to do a transaction, which you may be doing a basic search, or you may want to register a notice. So for the basic search, that can be done free of cost. but you only get limited information. If you want more, then you have to top up your account, and you can do so utilizing either a credit card, or you can come in office, pay some funds, put money on your account. Once you have done that, if you are in an organization, you can grant various levels of access to different persons in your organization. So they can go in, for example, they can register notices, they can see when a notice expires, they can set certain alerts so they know when to terminate, when to renew, they can search, you know, to see who are secured creditors, which assets are pledged. So that is the kind of access granted. So whereas we do not have general access to all members of the public, for persons who wish to do business, and as you can see, the barriers are not great, but just in the interest of protecting for privacy, we have put in different tiers of access. So the public can access by creating an account, and they can get basic information. If they want more information, then they have to pay a fee. And if they want to register notices, whether it be amendment, termination, then there's a charge for each of these various notices.
Member Hilton.
No. Member Morris.
Sorry, you did points. Thank you, Member Robinson.
Okay, thank you very much, Mr. Chair, and sorry for being late. You know, I'd gotten the information and was fully prepared for the meeting because of the excellent brief that came from your team, and I want to also commend them. But you know, in the whole preparation, boops, I don't know what happened to my computer. All the voice, all the voice programs on my computer have gone down, and we were trying to repair it at home, so I have to take it to Parliament, to the technician to see what is really happening. So, you know, that sort of restrict my participation here. But I want to ask a question along that line, because a lot of the assets that are owned by persons with disabilities are really assistive technologies. So you would have somebody with a laptop, and it is standard laptop, so, you know, but they have a software to it, and the software now is very expensive. I mean, you're talking about $1,400 US, so it increases the value of that asset significantly. I mean, how are we going to treat assets like that in the context of this piece of legislation, knowing that some of them are assistive devices that the person with disability cannot do without?
So thank you for that question, member, committee member. So for those type of assets, they are still now widely used by, especially the security, by the microcredit lenders. So we see where those are widely used, how they are treated. So the normal modus is that the debtor retains possession of the asset, and they make their monthly payments. But if they default, then the creditor would have a right to seize and sell those assets. But they do allow the debtor to continue using the asset, and as long as the debtor meets their monthly obligations, then, you know, they can have the best of both worlds. So that's what we've seen operating with those kind of assets.
Thank you very much, Senator Morris. And I'm going to bring in Member Hilton. But before that, I just want to add for the complete record that Mrs. Yvette Sutherland Reed from the ministry was very, very involved in the preparation of this, the permanent secretary, of course. It's the whole team and across the board, JIPO, but really spearheaded by company office. And I love to see that that kind of collaboration that produce this kind of product that members can feel confident about having it and making sure that as the JSC goes forward, this Joint Select Committee does the thorough work that is expected of us. Thanks again. Member Hilton.
Thank you, Chairman. And I too want to associate myself with the remarks about the quality of the information that was provided. And I want to, as I go back through the minutes, I want to commend Senator Sofa Fraser-Binns, who it was that asked specifically that this kind of work be produced. And it was a good question. I thought it was a good request at the time, and the response has been very satisfactory and helpful. And I want to say, Chairman, we have the similar, we have the JSC with insolvency.
Yes.
And I believe the same kind of.
It's the same
Yeah,
team,
right.
except a different agency handling it.
So that's why I'm using the opportunity to say that.
It's going to be the same. It's a blueprint we have, Minister.
Yeah. It's helpful, yeah? and I know the information exists. So it's just a matter of pulling the information together and bring them forward. So I want to commend that approach and the work. Let me also say that the work here, and my understanding, Chairman, is that while we accept and I appreciate that these are some good recommendations coming forward for amendment, the various interest groupings will be making their presentation, some of them trying to limit what is being here, change it, but I believe that that sort of dialogue is going to be critical in making the final determination. So, but you put us in good stead to prepare for the work, for the presentation and the submissions to come. So thank you very much.
Just to confirm, member, that some submissions have been made. Some of the people who couldn't be here today to present their submissions, we just thought we wouldn't lose the time because we want to get there. So, and I think this has been profitable, but they are all coming. We don't have a lot. We advertise it on social media, so people might be sanguine or comfortable, but we keep advertising it to make sure that those who do want to submit do have a right and come in and talk to us about what they want to see us do with this legislation.
I raised it at the beginning and you have responded, but that's precisely why I wanted the creative industry, particularly the music industry, to be approached, because sometimes they're so busy doing what they do that they miss certain
They get
opportunities.
busy. They're busy.
Yeah, so I want us to approach them, because again, that's an area where this act was designed to really help that sector monetize a lot of the assets that are now dead assets. So I really look forward to them being approached.
Miss Edwards has a note from me in a WhatsApp to say that we have to meet afterwards to do the follow-up, and one of them will be to Minister Grange.
Thank you, Chairman.
You haven't seen the WhatsApp yet. It's on your phone. Are there, let me see, any other business that we must address, Ms. Coyne or anybody else?
It has been profitable.
Wonderful to hear that. We're expected to meet next week. I am going to ask Ms. Edwards to work with my office to make sure as soon as we know today we get the notice out so as many people can adjust their calendar to be here. I want this to keep going. I don't want us to lose the momentum. And I'm going to be out for at least another week after that, so I'd like to meet next week. Okay? Thanks. But you have to get to my office because she will tell me if I can or not. All right? But members, this is just to say many, many thanks for coming. I'm glad we found this very useful, and thank you again to the people at the ministry and elsewhere at the agencies that have put this together, and we look forward to our next meeting.
No one is immune to mental illness. Your age, race, gender, social class, or economic status is no match for addictive behaviors, anxiety or eating disorders, depression, or schizophrenia. What is having a good social support system. As the saying goes, in times of test, family is best. Unfortunately, many are denied the benefit of the support of family and friends because of stigma and an oppressive silence around mental illness. Let's put an end to the silence.
Speak up.
Speak now.
End the stigma.
Share your story.
End the stigma.
A message from the Ministry of Health and Wellness.
Good morning, ladies and gentlemen. Honorable Prime Minister, Mrs. Honis, colleague cabinet members, colleague member of parliament, councillors, permanent secretaries, heads of agencies, and of course, the NROC team, which includes the Stephen Edwards and the board of NROC. So first of all, Prime Minister, I want to save the mischief makers from themselves by just holding up the gazette of this highway, which was gazetted yesterday evening at 5 o'clock. So we are in full conformity with the laws and regulations. So today we gather to witness a pivotal juncture in our nation's transportation history as a